haven't offered to have the matter settled out of court, they cannot proceed to do what they have done until parties have actually settled out of court. When we say
offered, who offered? They offered.
They offered to settle. When we say settlement out of court, what it's going to mean at the end of the day is this: the parties will sit down and reduce their relative positions into writing, and it will be termed terms of settlement. The two parties will sign. Their respective lawyers will countersign, and the court will make the terms of judgment its own consent judgment. Only then can you say you have
an out-of-court settlement.
Out-of-court settlement.
So would you say now
in our case,
you don't have that?
In our case, no. Parties are just beginning to talk. One, we were talking about compensation. We were talking about relocation. They gave us a piece of land, as we said. But we cannot access it. We cannot take possession of it because there were two rival claimants on
so
it.
You don't even have a written document with the court, with the judge saying that these parties have agreed.
We have not even sat down together to reduce it into writing because they were about fulfilling the first part, which is to relocate. They just barely showed us a piece of land. We diligently applied for certificate of occupancy over that fresh one, and they gave us.
Okay, which you have been given.
And they gave us. Now, the question that then arose was how we should take possession. We got there, we couldn't enter because there were other claimants on it already. We went back to them, and they attempted to be doing something serious. But you see, the police does not have the constitutional rule to keep policing land. That is not their primary responsibility. So they did it for just barely 2 days, and they abandoned us to our fate.
What are you planning to do now? Because it would seem that you are in a bind. You don't have your old structure. You cannot access a new land. Where have your members been worshipping?
This is the dilemma in which we find ourselves. This is the dilemma that the Enugu government has put the entire church. Our church is a 2-story building of 5,000 capacity.
So what,
a 2-story cathedral.
What do you hope to do now?
So what do we hope to do? Well, what do we hope to do? We are just hoping to see that they will see reason with us. Give us some compensation so that we can just put in anything on that land.
So they didn't talk about any compensation while all this was
going on?
Well,
they purport to be doing that. They purport to be, I use that word because they say they will be looking into it.
Because you're a lawyer, if you have a CFO on a property, don't you have compensation if the government is taking development that will affect that particular building?
That is what the law says. When you revoke a right of occupancy, you must serve sufficient notice on the owners or occupiers, and you must give compensation for the improvement on that land. So that's what we are talking about.
So that has not been guaranteed. How much are you asking for?
We are asking for 250 million naira. 250 million naira, and the structure which they demolished is actually in that region. It's actually in that region.
We understand it's a zonal headquarters or so for the MFM.
Yes, for the MFM.
Where does it serve? Is it just Enugu, zonal headquarters for Enugu?
Regional.
Or for the region?
It is regional. It is serving the entire region, the zones and the branches that are around there.
Just as an aside, pardon me, is this the first time the church is being, any church building or premises is being demolished across the country?
Well, let me say that this is the first one that I am aware of. This is the first one I'm aware of. We are law-abiding citizens. We keep to the law, so we don't ever have cause to be in conflict with the law.
So is there any fresh perspective as that before you came in here? Have they brought up any new perspective in terms of either compensation or what happens to the court order?
Well, this is our position. When the demolition was carried out, there was a subsisting litigation between the parties. 2, there was a subsisting and valid court order restraining the Enugu government and its agencies from carrying out the demolition. When that demolition was carried out, the Enugu government itself knew that its own out-of-court settlement initiative was still being implemented. When it was carried out, they knew that that church was sitting about 5,000 worshippers. When it was being carried out, they knew that we had no alternative means of accommodating our worshippers. When they were doing that, they knew very well that those worshippers, they have the right to associate and they have the right to practice the religion of their choice. So this is a case of executive lawlessness, a thorough abuse of the court process, a flagrant disregard of the rule of law, and unconstitutional democracy.
Well, so you'll be getting back to the courts to, of course, the courts. Are you going back to the courts to sort this out?
Oh, we have gone back to the courts. We have gone back to the courts. As I said, what they have done is a flagrant disregard of the rule of law, and we are pressing for contempt of court.
Okay.
The commissioner that is in charge must explain himself to the law. Why he had to do that? Why he had to show so much disrespect for the chief judge of Enugu State that was presiding over the matter. He had a cause to explain.
Mr. Bolaji Oninila, counsel to MFM, we'll have to end it here. Thank you very much indeed for coming.
Thank you very much, sir.